Good day, and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion amongst experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in today's episode, we're discussing a recent court decision that judges have said could threaten most every invention for which a patent has ever been granted, turning the patent system into a litigation gamble. In this month's episode, Dr. David Jackrell, president of Jackrell Consulting, leads a discussion into American Axle's recent bid to have the Supreme Court overturn a lower court decision that invalidated the company's patent in a closely followed legal battle with rival NIPCO Holdings. This case offered a much-anticipated opportunity to more broadly clarify patent eligibility in a time where many believe that court precedent has undermined the U.S. patent process, and in the words of retired U.S. Court of Appeals Chief Judge Paul Michel, confused and distorted the law of eligibility, making it an illogical, unpredictable, chaotic mess. Critics of these rulings and the resulting present state of IP law claim that the confusion and inconsistency has led to courts canceling many patents that should be protected. The Solicitor General has stated that problems arising from the application of Section 101 have made it difficult for inventors, businesses, and other patent stakeholders to reliably and predictably determine what subject matter is patent eligible. Despite cries for help and urges to provide clarification from multiple presidential administrations, the Solicitor General, members of Congress, the Federal Circuit Court, IP bar associations, and the Patent Office, the Supreme Court refused to hear this case, leaving many inventors and industries in limbo, since, as a USPTO spokesperson said after the ruling, innovation cannot thrive in uncertainty. I want to pause for just a second and reflect on the fact that these people are using this language. You typically don't see these kinds of animated responses and blunt warnings from folks in and around this field. On this podcast, we err on the side of under-sensationalizing, since there's plenty of the opposite available literally everywhere else you turn. But this issue is a big deal, and these aren't just firmly twisted knickers. These are serious people using very strong language. Investing in innovation is a long game, and one that requires some basic level of predictability and stability around idea protection. Alright, so beyond this being left unresolved by the Supreme Court, there's also the unfortunate precedent that may now very well seep into industries once believed to be immune from these subject matter limitations. Prior to this case, the subject matter eligibility problem was primarily confined to software and biotech. It was widely understood that physical products and their manufacturing were implicitly exempt from being ruled abstract ideas or laws of nature. What box was just left open? In today's episode, David and our all-star patent panel discuss the case law, its implications, how present statute is being conflated and taking Section 101 well beyond its gatekeeping function, and in their analysis of the American Axle patent, provide some great tips that may have changed American Axle's present fate and can hopefully improve your odds of success if approached early enough and intentionally at the drafting stage. David is joined today by our always exceptional group of IP expert regulars you know and love, including Dr. Ashley Sloat, President and Director of Patent Strategy here at Aurora, Kristen Hansen, Patent Strategist at Aurora, and David Cohen, Principal at Cohen Sciences. But we'd also like to introduce you to three new participants making their patently strategic debut: Armand Khosraviani, Patent Agent and former U.S. Patent Examiner, and the two newest members of Team Aurora, Ty Davis, Patent Strategy Associate, and Dr. Sophia Lee, Patent Strategy Fellow. Now, before taking you into the thick of this conversation, one that is especially technical and legal, as we often do, we wanted to provide a quick primer on a few concepts that could use some extra color and context for those newer to patenting. This episode builds on many foundational patent law concepts we've been exploring in prior episodes, so this will just be a speedy review, but I'll provide pointers and links in the show notes to the related episodes should you want to go deeper. Since this episode is largely centered around the concept of subject matter eligibility, we're first going to talk about rejection and invalidation gates. When patents are examined by the Patent Office or later litigated in a courtroom, several sections of U.S. statute come into play in determining if the claims in the patent are eligible, useful, novel, non-obvious, and enabled, or properly described. Patents can be rejected or invalidated if one or more of the claims are determined to be otherwise. Problems fall under the following sections of U.S. Code Title 35. Section 101, Patent Ineligibility or Lack of Utility. Section 102, Lack of Novelty. Section 103, the claimed invention is obvious, and or Section 112, Lack of adequate description. Today's conversation focuses on sections 101 and 112. We dissect these and relevant case law, including the referenced Alice decision, in much greater detail in Season 2, Episode 1 on software patents, and Season 2, Episode 5 on fortifying life science patents. For now, though, the important things to note are that Section 112 centers around enablement, or describing the invention in sufficient detail to allow it to be practiced by someone skilled in the art without undue experimentation. You're trading disclosure for exclusivity. That's fundamentally the deal, so you can't hold back on the details. Section 101 covers eligible subject matter. The Patent Act says that an inventor can patent any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. Historically, this was broadly interpreted and patents were rarely rejected or invalidated based on it, while instead utilizing the other sections to weed out patents undeserving of protection. More recently, however, this has changed, with the courts breathing judicial exceptions for eligible subject matter into being that don't exist in written law. These exceptions have become 101 grounds to reject and invalidate claims centered around laws of nature, natural phenomena, and abstract ideas. The sticky part is that despite the courts creating these exceptions, they've yet to provide clarity and objective guidelines or definitions around what these words actually mean, leaving it up to the lower courts and the Patent Office to sort through the ambiguity. This episode also focuses on distinctions between the spec or specification and the claims of the American Axle application. For a deeper understanding on all of the parts of the patent, check out Season 1, Episode 9 on patent anatomy. But in brief, the specification describes the invention and provides the context for interpreting the claims. The claims themselves are the heart of an application and point out the exact invention boundaries of what the applicant believes she's entitled to own, specifically what the patent covers, clearly defining the subject matter for which protection is sought. And one last acronym to unpack before I send you off, the group often refers to the CAFC. This is the United States Court of Appeals for the Federal Circuit. This is the federal court that hears appeals on business activities, including patent cases that make their way up from district courts. Much of the case law conversation will center around majority and dissenting opinions from this court. And with that, hopefully you're now ready for the deep end. Take it away, David.
The overview of the talk will be that we'll actually look at the claims first. I wanted to take a little bit of it rather than diving right into the opinion and getting adulterated by the opinions. I figured let's look at the claims ourselves, see what we think, talk about that a little bit. And the question really in this case is this patent directed to a method for manufacturing a shaft assembly in a driveline system, or is it really just directed to a natural law, as the CAFC majority, basically says in at least for one of the claims? So we'll talk about the claims, we'll talk about the court decisions, then we'll dig into the actual patent, the spec a little bit, some of the dependent claims, which is kind of interesting, and then we'll spend the rest of the time talking about the majority and the dissent opinion, because there's some really interesting stuff in there. And the Supreme Court, actually, we'll talk about a little earlier, they declined to hear the case. One of the reasons why we're talking about it now. This is a method for manufacturing a shaft assembly for a driveline system. It's a shaft of a propeller or a shaft of a car, you can see here. So it's a shaft, and there's vibrations in the shaft, and they have, there's a first driveline component and a second driveline component, and the shaft transmits torque between them. So you have this hollow shaft member, you're providing it. And then the second clause here is tuning at least one liner to attenuate at least two types of vibration transmitted through the shaft member. And then they talk about positioning this liner within the shaft member. And this is the big difference, I feel like, between claim 1 and the other independent claim, which we'll look at. This claim has a little bit more meat here under the positioning step. It's positioned, but it's positioned such that it's configured to damp these shell mode vibrations by an amount greater than or equal to this 2% number. And also it's configured to damp bending mode vibrations within 20 plus minus 20% of a bending mode natural frequency. So when I first looked at this claim, I thought to myself, that word tuning is a bit weird. someone, of course, 101 is on my mind as I'm reading it because I know that that's a big crux of this case. So how problematic really is that word tuning? And when you look at the claim construction, this is a quote from the CAFC opinion, but it's basically that the district claim used this construction, is that tuning the at least one-liner means controlling characteristics of the at least one-liner to configure the liner to match a relevant frequency or frequency. So that came from analyzing the specification, and neither party really disagreed with that claim construction. So keep that in mind, because tuned, you might be a little bit vague. And so when you see tuned, it more or less means configured to perform these things.
Hey, Dave, how, not having read their spec, how much did they go into how those characteristics are defined? It says controlling characteristics of at least one liner, or defining what those characteristics are, or how they teach somebody to figure out those characteristics or how to control them. Do they go into detail about that?
Great question. Absolutely. I have a slide on that because I think it's like very important. And so, yeah, like slide 6 or 7 or something like that, we'll get back to that. So just hold that thought for a minute. The short answer is it's a short spec. They do describe it, but a big difference of opinion between the majority and the dissent is how sufficiently it is described. So it's not an easy thing to answer. I think we should look at it. Yeah, it's a great question. The second independent claim, 22, it has the exact same preamble, providing a hollow shaft member. In this case, instead of tuning the liner to attenuate at least 2 types, blah, 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 it's just tuning a mass and stiffness of the liner. And then instead of positioning, it's inserting. There's a little bit of like discussion about, are those words really different? And then the wherein clause here really just says that it's tuned resistive absorber for attenuating shell mode vibrations. And also it's tuned reactive absorber for attenuating bending mode vibrations. So they do have the 2 different vibrations in there. But again, they use that word tuning. And again, the district court construed that tuning essentially to mean controlling the mass and stiffness of at least one liner to configure the liner to match these relevant frequency or frequencies of these vibrations, as basically defined in the spec. So what happened in court and why are we talking about this case? The district court said claims 1 and 22 were patent ineligible under 101 because they related to a natural law, basically, and nothing more. It failed step 1 of the Alice 101 test, and it also failed step 2, in their opinion. In October 2019, the CAFC took up this case on appeal, and they affirmed both of those decisions. Claim 1 and 22, both patent ineligible. 10 months later, they followed it up in July of 2020 with a modified opinion, which changed their mind on claim 1. Claim 1, they decided should be remanded to the district court because, and we'll talk about this more, but because it wasn't as clear. It wasn't as clear as claim 22. There were more elements in claim 1 that the CAFC determined were not sufficiently litigated, sufficiently discussed and argued in the district court case. So it was remanded so that they actually take up those considerations more thoroughly. So what recently, the big news last month in June is that the Supreme Court declined to hear this case. So why? What happened there? President Joe Biden's administration in May urged the High Court to take up this case, saying that American Axle's invention was a classic example of patent-eligible industrial process. So the Federal Circuit decided previously in a 6-6 deadlock not to rehear the case with all of its judges in an en banc. The dissenting judges said the panel's decision could threaten most every invention for which a patent has ever been granted, and that the court's eligibility rulings had turned the patent system into a litigation gamble. So a lot of strong language on both sides. You'll see the dissent is, what did they say? Vigorously worded dissent. And I have some good quotes that I'll share later. So the dispute left the Federal Circuit bitterly divided and at a loss. And the Supreme Court denied to hear the case. Similarly, in 2012, all 12 of the Federal Circuit's active judges at the time asked the Supreme Court to hear another similarly divisive case that was also in the 101 realm. And the court rejected that, despite a recommendation by former President Donald Trump's administration to back it up. So everyone, and then the Patent and Trademark Office spokesperson said that the ruling said after the ruling that innovation cannot thrive in uncertainty, and the Patent Office is committed to making every effort to ensure that the patent system is as clear and consistent as possible. So it seems like everyone, presidents and the Federal Circuit, and there's even certain Congress, people in Congress who are on the record as wanting the Supreme Court to weigh in on some of these things, and the Supreme Court has so far denied and refused to do so. So the only thing we have to go on now is this CAFC modified opinion from July 2020.
And David, to add to that, as a practitioner who deals with 101 responses a lot, you also have two claims that technically they have the two things that you're supposed to have to overcome 101 rejections. They have a practical application or two,
right?
Dampening, making sure something is tuned in order to carry out something else, right? And they are an improvement to what's out there, which is shown in the specification, I believe, but also if there's no art here, no one else has been able to do this for this field, right? So you have an improvement to a technical field. But the thing that makes this little quirky is it's dealing with a natural law, Hooke's law, springs. These are things that people say, well, that's obvious, but they forget you can have a piece of obviousness in a 101 rejected claim as long as you can still show that there's practical application, some novelty, or I guess improvement to a technical field. So this is one of the first cases where the standard toolbox that we have of overcoming 101 rejections cannot be used. And it seems to already be in the claim, but they don't even want to hear it because they're like, no, natural law.
It's your points are almost exactly what the dissent argues. And those are super valid points. And I think, I actually think that the majority has some valid points and the dissent has some valid points. It's a tough one. It's like you said, there are additional elements in the claims. At the same time, if you just consider claims 1 and 22, we'll talk about it in a minute, maybe that's not the best idea. If you just consider those claims, it is a little vague about what they really mean. And it almost is, because tuned goes back to configured, it's almost functional language. Now you have to go back to the spec. And does the spec really teach someone how to do that? But then you got to say to yourself, wait a second, is that 112? Is that 101?
Right.
So it gets very convoluted. And I guess I sort of agree that there are some issues, you know what I mean, with this patent and the claims and the description and the way that it's all comes together. But should it really have been rejected at all? And should it have been rejected under 101 or invalidated?
That's my question. The 101 issue, if you take a spring and you say that anything to do with spring cannot be patented, that's a slippery slope, right? So, exactly. I mean, I think that's the majority's thought there is, wait a minute, it's not just a spring, but what else do we know, right? And the specification on this case isn't teaching enough for everyone involved to be comfortable. So
that's
anyway,
the
go on.
112, 101 issue, right? Maybe it should have been 112.
And I see that as a totally valid point. And then I also go back to thinking about functional language in the claim, and that what does it really mean to tune a liner if the specification doesn't teach someone really how to do that? Anyway, it's a great point, Kristen. Excellent points, and we'll talk more about it and see some quotes from them about a lot of those points as we.
I just wanted to add something really quick for examiners. So they're trained to ignore functional language when it comes to device claims. So for an examiner, they might have not actually given that word tuning any weight, unless the applicant or the inventor provided support through, what a person of ordinary skill in the art would consider tuning, or maybe prior art would provide some teaching of what tuning would be, or how they could construct tuning from the prior art.
Right. That's a great, I know exactly. It's a great point. And yeah, you can see like that the CAFC found claim 22 ineligible in their modified opinion. And they said it simply requires the application of Hooke's law to tune a prop shaft liner. So even when they're talking about this, natural law, it goes back to that tuning. That tuning is really key. However, claim 1 is remanded. And what they said about that is, well, claim 1 also requires positioning in addition to tuning. And they saw that as different than inserting. Positioning, it evoked a position, putting it in a particular place rather than just inserting anywhere. And also may reflect a broader definition of tuning. And if you go back to the claims, claim 22, which was found patent ineligible, says tuning a mass and a stiffness. And David, don't worry, the next slide is about Hooke's law. But tuning a mass and a stiffness, that just evokes Hooke's law to people very clearly. But claim 1 just says tuning at least one liner to attenuate at least these two different types of vibrations. So then you got to go back to the specification, and this is potentially a broader definition of tuning that involves not just the mass and the stiffness, but other things as well. So then it's not as clear that it's just Hooke's law is their kind of thought process on claim 1. So to give some quotes to give a little more explanation of that, there's like 1 or 2 paragraphs on step 2 of the 101 framework, and this is a big problem that Judge Moore had in the dissent. He didn't think enough weight was given to step 2, but they did talk about step 2, and they said that there's no inventive concept because the invention was a trial and error application of Hooke's law. So some quotes: what is missing from this claim, this was about 22, the ineligible one, is any physical structure or steps for achieving the claimed result. And that the real inventive work lies in figuring out how to design a liner to damp 2 vibration modes simultaneously. And no such inventive work is recited in claim 22. And to go even a step further about the 112F, the means plus function stuff, they also clearly considered the specification. They say the specification describes tuning in terms of the result achieved, rather than the particular process by which the result is accomplished. And I'll show the paragraphs in the next slide or two so that you can see for yourself what the specification actually says and why the majority opinion says this, whereas the minority dissenting opinion says something else. So Judge Moore in dissent had 3 major issues. One, he said, no, these are not directed to a natural law. This is a method of manufacturing a liner for a drive shaft. He also argues that there were many articulated inventive concepts that should have precluded summary judgment, and that step 2 was not given sufficient weight. And then the third one he argued was that they were conflating patent eligibility under 101 with the principles of enablement under 112. And in a great quote, I feel like, is that in Judge Moore's view, this is from an article, in Judge Moore's view, the majority found the claims ineligible because the patent did not teach a skilled artisan how to tune a liner. So we'll dig more into each of these things as we go. And we already talked a little bit about the means plus function. So let me just get to what we've all been waiting for. What is Hooke's law? So everybody might remember, if they took physics like in high school, that Hooke's law is this simple equation here. Force equals K times X. K is the spring constant and X is the displacement. So if you have a spring, it has a particular property, a spring constant. And if you apply a force to it, it will extend by an amount X. And if you double the force, for instance, by hanging an extra weight on a spring, doubling that force, then the displacement will extend twice as far. So that the displacement is just proportional to the force, and that proportionality constant is the spring constant K. In this case, we're talking about frequencies and and dampening vibration frequency. So this is a little bit of an extension of Hooke's law, if you will. It's an application of Hooke's law, that if you have this situation where you have a mass on a spring and you pull the mass to extend the spring and then let it go, what's going to happen? It's going to oscillate. It's going to try to get back to its equilibrium position, but it has some momentum, so it goes past the equilibrium position, and then it'll continue oscillating back and forth. And since this sort of an oscillator obeys Hooke's law, you can solve the equations for frequency, and you find that the frequency of such an oscillating system only depends on the mass and the spring constant. It does not depend, for instance, on the amplitude of the oscillation. So due to friction, due to other losses, right, air resistance, what have you, those oscillations will slowly dampen over time and it will stop, so that the amplitude will go down over time. But the frequency as it's going down stays the same, similar to the situation of a pendulum, right? And so what's interesting about this is that this invention, this law of nature that was applied in this way, was used to construct the first pocket watches in order to get an oscillator that would be portable and you could move around in all different orientations, unlike a pendulum or a grandfather clock or a lot of the more elaborate, complicated mechanisms of the time. Using a little mass on a spring allows you to make a mobile timepiece, which was like a huge advance in navigation in history. So, and Hooke was one of the inventors of that clock, of those watches. By the way, it wasn't a linear spring; it was a spring, a coiled spring, and there were other kind of mechanisms in there. It was a little more complicated than just a mass on a spring, but it was this Hooke's law, and that's where you see this mass. You see the stiffness, the spring constant, and the mass. And if you tune those two things, that's Hooke's law in some abstraction. So even though the claims never say Hooke's law, tuning a mass and a stiffness of a liner to tune the frequency of that liner, this is where the district court originally and the CIFC agreed that it was directed to a natural law, Hooke's law.
Quick question, David,
yes,
just
absolutely.
For a little bit of clarity. I'm just trying to, when you're tuning that liner, they're tuning for your torsional frequency and also the bending frequency of the axle. Am I interpreting that right?
But yeah, that's right. They do talk about torsion. The claims talk about the bending mode, and also this shell mode, where the actual, this is like a cross section of the, right. But the torsion mode, even though they describe it and everything, it's not one of those two modes that's claimed. Yeah.
So you're trying to find the optimal point kind of between the two in the tuning, correct? You're trying to find the spot where you fix the torsional and the bending.
That's a great point. And this is one of the things that American Axle argued unsuccessfully, is that tuning to dampen two vibrational modes at the same time is not so simple. And it's not just a simple application of Hooke's law. It involves a lot more. And we'll get to that in a few slides. I know it's just like there's a lot in this case, like I said at the beginning. Hopefully we'll have time to get to that. But that the district court essentially and the CFC agreed that the even though sure American Axle may have invented a whole bunch of things to tune these liners in this way using finite element modeling, et cetera, that was not in the claim, and it's not even in the spec. And I think that's a huge problem, actually. The word finite element modeling doesn't even show up in the spec. The spec is very short, and it does, it's kind of a good segue, it does describe this liner as a physical element. It has a lot, like Kristen was saying, it has a lot of these like practical application things that we look for, right, to get around 101. So it's got this physical element, this liner 204, and it describes these bending modes or vibration modes, bending mode, shell mode, torsion mode, right? And so it goes into that. It goes even farther, and it says that the characteristics of this liner can be controlled to tune its damping properties in these particular modes. For instance, They talk about mass, length, diameter of the liner, and they describe this liner, structural features of this liner. They say it has a resilient member. The resilient member can have a helix angle and a pitch. There's other structural features to this the liner. And then they give a particular example, a particular quantitative example. Here's a drive line that has this diameter, wall thickness, length, etc. And here's a liner that works in this situation. So they do give examples. And then this, I think, is getting to the crux of the issue. What they say in the next paragraph is that it'll be appreciated in certain situations. It's not possible to exactly tune the liner to 2 or more relevant frequencies. And as such, it will be understood that liner 204 will be considered to be tuned to a relevant frequency if it is effective in attenuating vibration at the relevant frequency. And this is exactly the sentence that the majority points to say, the specification only describes tuning in terms of a result to be achieved. It doesn't describe the steps that one must take to tune a liner. The dissent disagrees. And you can see here that there are structural elements that are described about these liners. And I think this is a really interesting, I think, side note on this case too. There are 7 or 8 dependent claims off of both of the independent claims 1 and 22 that do specifically claim these structural features. You've got this resilient member, you've got the resilient member extends helically or longitudinally or circumferentially. You've got different materials involved, cardboard, plastic, carbon fiber, and even some dependent claims about positioning the liner symmetrically about a bending antinode and things that are actually like very more or less specific structural features of these liners. So what the majority says is that the district court, and this is what happened, the majority and the district court treated independent claims 1 and 22 as representative of all of these dependent claims. And the dissent disagrees with that entirely. The dissent says, I do not agree with the majority's conclusion that claims 1 and 22 are representative, or that American Axle waived its arguments as to the dependent claims. First, NEPCO, who was the other party in the case, never argued that claims 1 and 22 are representative. In fact, argued the dependent claims separately. And American Axle expressly argued that they're not representative. And I think, this kind of, it seems like a small thing in some ways, like, oh, claims 1 and 22 are representative. We're just going to go with that. We're not even consider dependent claims. But if they had, it might have been a lot harder for them to say, no, there are no structural features here that teach one how to tune this thing. They may have came to the same conclusion due to, for instance, inadequacies of the specification. To even though there's a helical resilient member, how do you tune that helical resilient member to dampen a bending mode at a particular frequency?
That's what I see as missing, by the way, entirely. The crux of that invention is the tuning and or the positioning, and nobody's saying position until, position why, position because. I mean, there's just nothing in there. So I guess I fall somewhere in the middle. I think there's enough structure to get you out of 101, but I don't know that there's enough content and teaching to get you over 112. Right.
Yeah, right. And the dissent actually almost uses the exact same argument. They say they totally disagree that it should be ineligible under 101. This is absolutely eligible under 101. But they actually left the question open. They said there are many inventive concepts that go beyond natural law, but they leave it an open question. Is there sufficient enablement to satisfy 112?
I feel like this is like a common thing with the courts, though. Like they, by their like partial opinions almost that they give, they leave more ambiguity than they do fix it. Like, the whole Google Oracle case, we're going to kind of rule on things, but we're never going to tell you if APIs are actually copyrightable, right? We're going to kind of leave that. And then same with this case, okay, yeah, we're good for, certain of the judges believe that it's fine for 101, but we're not going to like address 112, and they kind of leave it, and I know it's because, there's a whole bunch of rules and how things proceed in court proceedings and things like that. But, I feel like we're always like doing 90% and then we never take it the last 10%, which would, I think clear up some of the ambiguity.
Yeah. Yeah. Kristen and Ashley totally agree. And I actually wonder, I don't know, I haven't read anything about this. I'm not totally sure what the Supreme Court was thinking, but I do wonder if they declined to take the case because it is a little bit complicated and not an ideal, it's a little bit messy. It's not a really clean 101 discussion. There's like a lot of different things that go into it. So yeah, maybe. I'll try to get some highlights now. We've talked about these things a bunch. The majority says that Claim 22 confers patent coverage if the attenuation goal is achieved by one skill in the art using any method, including any method implemented by computer modeling and trial and error, so that the claim on its face does not identify the particular tuned liner or improved method of doing that. And it's a really interesting quote. American Axle argued that one could infringe Claim 22 by whatever means will achieve the result, even if you didn't try to tune it and didn't know you did it. So that kind of, I think, maybe worked against them in some ways, because it fed into this argument that it's not a clear, concise, explicit invention. It's vague and results oriented. That right, none of these, so the majority concedes, or at least it argues, that these established processes and improved processes are not claimed. American Axle may have discovered patentable refinements, such as particular uses of a sophisticated finite element analysis model during its design process, but neither the specifics of any novel computer modeling or of any experimental modal analysis are included as limitations in Claim 22, and also the specification only describes tuning in results of in terms of the result achieved rather than the particular process by which it's accomplished. So, what the majority says is what's missing is any physical structure or steps for achieving the claim result. Now, to be fair, the dissent argues against that, because the dissent is looking at the dependent claims and says, that's not true. There are physical structures and steps for achieving the claimed result, at least an attempt to put those structures and methods in there. But I think, to Ashley's and Kristen's point, was it enough? Was it enough? I think that's a tough thing to answer. And I did want to hit on these two, because I think this is really interesting to just, this isn't in a vacuum. There is case law that Supreme Court ruled on and that the CAFC relied on. So there's this really important case, Parker v. Fluke, which was a 1978 case about calculating and updating an alarm limit. And they found that patent to be patent ineligible under 101. And the reason why is because, as in Fluke, the claim method did not specify how variables were measured or how the alarm system functioned. Claim 22 here does not specify how target frequencies are determined or how, using that information, the liners are tuned. So this is in contrast to a Deere case, Duaman versus Deere, which was patent eligible under 101, and it recited a calculation for a mold in a process to cure rubber, a mold temperature calculation in a process to cure rubber. And in Deere, unlike in this case, these other steps apparently added to the formula something that, in terms of patent law's objectives, had significance. In other words, they transformed the process into an inventive application of the formula. So there was enough, in Deere, there was enough described. They talk about, yes, it relied on this equation, but they also described how to use and implement that equation, and therefore transform the process into an inventive application.
What this is saying is basically the application lacked an embodiment where those elements, those structural elements that contribute to controlling those frequencies, there wasn't some kind of enabling embodiment that disclosed how they should be adjusted, right? How they should be fixed or changed so that they accomplish the claimed invention.
Right, that's a good way to put it. Exactly. They were trying to claim a result without structural, components or method steps that unambiguously, clearly taught someone how to achieve that result. Then you can argue back and forth again, is that a 101 issue or is it a 112 issue? But I think we kind of all agree that there is an issue, with that. You can't, right? So it's a lot a lot more we can say about that. But interestingly, I didn't know this, fluke was actually also used by the Supreme Court to support Alice. And they say in the Alice case that fluke is to the same effect. And that fluke stands for the proposition that prohibiting against patenting abstract ideas cannot be circumvented by attempting to limit the use of the idea to a particular technological environment. And it's interesting, that was a quote from Bilski. So this fluke is all over the place. And it kind of like what Kristen was saying, it's clearly a particular technological problem that they're trying to solve. And what fluke apparently is used for by the courts is to say that's not enough. Just saying you're going to apply a natural law to a particular technological problem without sufficiently explaining structural and or method steps that explain how to apply that natural law, just putting it in a technological environment is not enough. So I thought that was pretty interesting. That's something that is like now, I think in some ways, I feel like this American Axle case is people are up in arms about it for sure, and a lot of people are talking about how different it is from the case law history and how they've totally just taken a left turn. And I think fluke is what they, in their mind, in the majority's mind, fluke is what helped them actually bring it all, make their decision in light of the prior decisions, not completely a left turn from those. So claim one is a little bit different, right? And we talked about that. The CAFC said that claim one could be an abstract idea, but that this abstract idea was not adequately presented and litigated in the district court. So that's why they remanded it. They didn't really put any hint about whether they thought it should be eligible or not. They just said that there's more in there that was not adequately argued, and therefore it's not proper for the CAFC to make a summary judgment on these facts or rather these aspects, because they weren't sufficiently handled at the district court level. So now it's been remanded. Okay, so the dissent. This is fun. The dissent actually says that this majority's holding that these claims are ineligible has sent shockwaves through the patent community. So there are some great quotes in here. The first one is from Representative Doug Collins. It's unthinkable the courts found this invention a manufacturing process for making a key automotive part as patent ineligible. The next one, which was a Bloomberg article, said American Axle is a poster child for how the current test for patent eligibility is being applied to reach rather absurd results. And that if industrial processes, physically based patents like these are ineligible under Mayo Alice, then seemingly every patent is in ineligibility jeopardy. You just go on and on, right? There are some fun quotes in there, but clearly there's a lot of controversy about this case. So what does the dissent say? The dissent has some vigorous language and basically talks about sort of two different things. The first thing is about how natural laws in this case, and step two of the Alice Mayo 101 analysis, which is there something that's significantly more than just this abstract concept or natural law? So as the defense says, A disturbing amount of confusion will surely be caused by this opinion, which stands for the proposition that claims can be ineligible as directed to a natural law, even though no actual natural law is articulated in the claim or even the specification. So that is a really interesting statement, because that apparently is pretty different from most, if not all, of the previous cases in this area. Previous cases all talked about natural laws or even claimed natural laws in some way, whereas this case didn't. And that goes on to say, holding these claims ineligible under a purported natural law analysis leaves patentees awash in a sea of uncertainty. How can one determine if a claim is directed to a natural law without a natural law being apparent either on the face of the claim or under a proper claim construction? He goes on to say, goodness sakes, the dependent claims held ineligible by the majority specify the material the liner must be made of, the actual physical form it must take, with fingers circumferentially wrapped or overmolded, and the place the liners must be positioned. And he says, it is remarkable that the majority thinks that claims with all of these very physical, very concrete, very structural limitations are missing any physical structure or steps. A fiberglass liner with a helically shaped resilient member extending circumferentially around the liner or overmolded to the structural portion of the liner certainly feels like the physical structure that the majority says is missing from the claim. And, the district court and the CAFC were very clear that they were not looking at dependent claims. They were saying that claim 1 and 22 were representative. And I think what the dissent is saying here, Judge Moore is saying, is that that was a mistake.
So David, one of the things here that is a little bit hidden, when you say structure or steps, I think the way the court uses that language really is you're missing structure or you're missing steps. So in this case, it would maybe be missing steps, even though there's loads of structure.
Right.
Yeah.
Right. I know what you mean. Yeah. Right. And, missing steps, exactly. Missing steps, maybe teaching someone how to tune.
Yeah.
And then how do you teach someone how to tune? You've got to talk about maybe it's a finite element model. It could be a process. They could describe some kind of process they go through, or they could describe some kind of a structural, a process of changing a dimension of a structural feature or whatever, right? So yeah, I know you kind of gloss over structure steps. Yeah, right.
It could be as simple as like in Diamond v. Deere, where they do something until something occurs, and then that is how the problem is solved. So
right.
Another step maybe would have helped them. I don't think they had it in their specification, but if they could have, just adding that to the claim might have helped them.
Right.
I also just wondered too if the broader claim would have been okay had they had a few examples in their spec that said, here's one way to do it, here's another way to do it. And obviously they had the structure there, so they would have just kind of packaged those into a few examples of, again, we deserve this broad claim because here's 4 different ways to achieve this breadth, right?
Yep.
Again, a 112 issue,
right.
More so probably.
Right. I know. It does. I think there would have been, if this was invalidated due to 112, I think it would have been a lot less controversial. Would that have been correct? I don't know. But I feel like the invoking 101 in this case really made matters worse. It didn't had clarity. It sort of made things more confusing. So I get why there's so much controversy about it.
But I think that's the bigger issue in general with patent law right now. I think they're kind of mushing together all of the things, right? You have these practical application, inventive stuff in 101. You have some 112 issues in 101, 101 and 112 being conflated. You know what I mean? You're kind of, I feel like you're trying to make a one size fits all test, but then saying it's only under 101. You know what I mean? But yet it encapsulates all the different.
I think that's
sections.
Even. I don't know if I put that in, but almost exactly that. The dissent actually just said that in a paragraph, that there's 101. It's carrying too much here. We just talked about natural laws in step 2. Again, the dissent, like Ashley was just bringing up, didn't agree that with the majority, and that thought the majority was conflating 101 and 112. And so he says, Judge Moore says that the majority's concern is not preemption of a natural law, which should be the focus, but rather that the claims do not teach a skilled artisan how to tune a liner without trial and error. So it's clear from the claims themselves that the functional result is the drive shaft with reduced vibrations. It's undisputed that there exist many ways to attenuate these things, including these physical structures, and that the only remaining question is, would a skilled artisan know how to adjust the mass, stiffness, and positioning of the liner in order to damp vibration without undue experimentation? And then he says, yes, this is a question of enablement, not eligibility. And like, this is what actually was this is the quote I was looking for, that, the majority's true concern is with these claims is not the directed to Hooke's law, but rather that they haven't claimed precisely how to tune the liner. And that he goes on to say the majority concludes that the inventive concepts make no difference, and his section 101 should not be this sweeping and this manipulatable, should not be used to invalidate claims under standards identical to those clearly articulated in other statutory sections, should not subsume 112, should not convert traditional questions of fact, like undue experimentation, into legal ones. And the majority's validity goulash is troubling and inconsistent with the patent statute and precedent. And the majority worries about result-oriented claiming. They are worried about result-oriented judicial action. This is the last sentence in their dissent. And then, I think there's an open question. If Judge Moore is correct, then would these claims be invalid under 112? I mean, I think there's a reasonable question there, but I definitely wanted to get to this because the majority actually responded to that. Since there was a modified opinion, that this quote I just put up was from the 2019 and original opinion. In 2020, the court says, third, the dissent criticizes our analysis as improperly merging enablement and eligibility. But we think the criticism rests on a failure to distinguish two different how requirements in patent law. The first requirement, that of eligibility, is of the claim itself, whether by its own words or by statutory incorporation of specification details under 112F. 112F means plus function, right? So it is the claim, but when you have means plus function claim, the claim has to be evaluated in reference to the specification. That gets really confusing really fast. And then they say, it must identify how the functional result is achieved by limiting the claim's scope to structures, etc. But the second distinct how requires application requirement applies to the specification, not the claim, where then the specification needs to teach someone how to make and use the claim structures. So their point was that this first how, possibly under this means plus function umbrella, that there has to be enough, you can't just claim a result. There has to be enough in the claim itself to claim something that is concrete, or else it's abstract or it's a natural law, and therefore it is ineligible under 101. And I think this is the best explanation I've seen that they've given for why they chose 101 and not 112 for their analysis. So who has some sort of parting thoughts, I guess?
I just have one simple thing. In my thought process, I never think about how when I look at 101 eligibility, ever. This to me screams 112. When you start asking how, but just an opinion. Yeah. Go ahead, Ty.
Interesting. I was just going to ask you, David, what your thoughts were. In kind of like boiling this down, do you feel that this is American Axle's, failure to recognize the actual invention? Because to me, it almost sounds like the actual invention they feel is just a tool on the way to the invention. And maybe that's why they under-disclose in the specification.
Yeah, that's an interesting question. Did they not realize that the invention was the tuning, or was it a business decision, for instance, to not provide a lot of details on the finite element modeling, et cetera, because they were trying to keep that a trade secret?
Yeah,
or
Right.
it could have been, in this like first to file world. I don't know, I guess when this was filed, so maybe it's pre that, I don't know. But, you always end up with this chicken or the egg problem, right? You have inventors who start to play around with something, right? And then you're like, oh, wow, this is going to be huge. We got to get this on file. And then the 1-year date comes along and they're like, yeah, this is still like, it's totally going to work. We got this, but exactly how it's going to work, we're not sure quite yet. So, but hey, let's go ahead and file this broader patent because, that's like, it's solid. We know it's going to be a thing. And then like, we'll do another application later that's like more species specific, right? That we're going to talk about this finite element analysis way of doing it. And then we're going to talk about this other helical, whatever material properties way of doing it. And, whatever. So you also wonder if, and I think that the first to file thing and provisionals and stuff are fantastic, but there is a little bit of this game that you have to play of when do we disclose, when do we convert, is the 1 year the appropriate time to convert? Is there a way, should we refile the provisional and restart that clock? And, so I also wonder if there wasn't some of that happening.
Yeah, interesting thought. Yeah, definitely.
There was one other argument that American Axle used, which I didn't have time to get to, but in their prior art search and in their knowledge, tuning, or rather attenuating bending mode vibrations in a drive shaft was never done before, ever, using any liner of any kind. And so I actually wonder, like you were saying, Ty, I mean, they may not have thought that the invention so heavily relied on this tuning. I think they may have thought that, well, let's talk about what we did in these independent claims in a really broad way, shoot for the moon, and then in our dependent claims, we're going to have all the detailed structural features that we use to achieve this result. And they may have been pleasantly surprised that claims 1 and 22 were allowed by the patent office, and I think that they're just beside themselves in that, like, wait, we have this structural, unique invention that no one ever did before. It's clearly a thing. It's not Hooke's law, and the way that the claims were drafted and the way that they chose 1 and 22 to be representative, and now the way that it's like very so broad with the tuning and tuning language and functional language. Yeah, it might have just been surprising. This whole thing might be surprising to them in hindsight. Maybe makes sense, but not something that they thought about up front. They thought they had this in the bag. They thought they had this great, solid mechanical invention that no one ever did.
They might have, but nobody knew.
Right, totally.
Yeah,
and maybe out with the bathwater.
Yeah.
Well, one thing we hadn't considered here, and we'll never know, was this a case where you had one practitioner writing the claims and another, maybe more junior, writing the specification, and not having some of those tuning details, just said, we just tuned it. These are the components used to tune it. This is some detail that I have, and then filed it. I don't know.
Yeah. They made the specs abstract and broad as well as the claims.
It would be interesting to be a fly on the wall for the history, of this one, right?
Right.
How did we get to where we are? I feel like that's, because American Axle, you don't really know what it means, right? It kind of has this obscure name, but it sounds almost kind of dark. So I feel like you could do a documentary, American Axle, a history in the making,
The controversial world of drive shaft liners.
Ashley, get Josh on that. Get Josh interviewing.
You need an investigative history. You find all the practitioners and the engineers and the business people at the company at the time. Why did you make the decisions you made?
Right.
People would probably actually watch it, given how much focus. At least I would probably if I saw that on Netflix.
Nice. Well, thanks everybody. It was a great discussion. Thanks for all your input.
Thanks for putting
I'll
together.
send the slides around.
Thanks, David.
Yeah, absolutely.
Discussion.
Bye.
Thank you guys.
Bye.
All right, that's all for today, folks. Thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion, or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.